Brought to you by the personal injury attorneys of Perrin, Caulfield, Averill, and Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening, and thank you for listening to FLA Law on the radio. This is Attorney Matthew Noyes. I'm one of the partners at Perrin at Caulfield, Averill, and Noyes. And every Tuesday, we come here from 5 to 6 to be available to answer questions for you. We are personal injury attorneys. We also do workers' compensation and Social Security disability cases, but we can tackle any questions that you may have regarding the legal field. So please, while the lines are still open, give us a call. The number is 727-441-3000. But I'm not doing this myself tonight. I have my law partner, Brian Caulfield, with me as well. Brian, thank you for coming.
Hey, Matt, thank you very much for having me on tonight. I look forward to answering some questions.
It's going to be a lot of fun. Brian, why don't you tell them, I know all about you. We've been working together now for, 30 plus years. Why don't you tell our listeners just a little bit about how long you've been in Tampa Bay and such?
Well, I actually moved here from up in New Jersey back when I was in fifth grade. Was here 5th grade to 10th grade. And then my dad was in the boat business, so we moved away to the state of Maine for 4 years, believe it or not. Wow. And then back here to the same house. I have been here ever since, and I consider the whole Tampa Bay area to be my home, having lived in Seminole up in the East Lake area and now out on Clearwater Beach. So wonderful area here in Tampa Bay. And we, of course, since our firm's been here since 1955, it's really amazing when you look around and see the explosive growth that's taken place here, all of which means more car accidents.
That's exactly true. Yeah, and Brian has been. His roots are here. My son goes to Clearwater Central Catholic High School, and the athletic director at CCC went to high school with Brian. So being here that long helps us to really appreciate helping people in our area, and the importance of knowing the area. We're not those attorneys that have TV commercials in the area that have offices in other areas of the state and come down here, but rather we are here in the courtrooms of Clearwater and St. Petersburg and Pasco County and even Hillsborough County helping out. Brian, I think one time you had a trial in every county, like in just a few months from each other. Isn't that right?
Yeah, no, I definitely am active, throughout the courthouses of Tampa Bay. I like to say I've had $1 million verdict on both sides of the bay. And so certainly, trials are something that we do as part of our practice, as you well know. But, many of our cases were able to get resolved because of our reputation and the skill that we've exhibited since 1955. And that helps clients get cases resolved without actually having to go to trial. And many clients are pleased with that because they don't want to go to trial if they can avoid it.
Yes, many of our clients think, oh gosh, I don't want to go in front of a jury. But about what percentage of cases actually go to a jury trial?
It's really surprisingly low. And, that's one of the things that I think surprises clients because they watch so much TV. They think every case ends, in a courtroom, like one of these 1-hour TV dramas. And in fact, most personal injury cases don't end up in trial and end up, getting the case resolved before the case actually goes to trial. And I'd say in the last 10 to 15 years, there's been a huge push to do alternative dispute resolution methods, whether that's by mediation or non-binding arbitration or binding arbitration. So there's almost like steps that you need to go through in order to ultimately graduate to a jury trial. The court wants to make sure that the parties, number one, have discovered the facts about each other's cases. And number two, they've really exhausted every possible means of settlement. Right. And only then do you end up getting a case. And of course, what's gone on in our world here since COVID, as well as we had some major changes in the law here recently, the backlog of court cases is unfortunately a problem. It's a problem for everybody.
Well, I know I have a case that we asked to get a case set for trial, and they set it for, I think it's February 2024.
Yeah, justice delayed is justice denied, as they say. True. So it is unfortunate. But right now, the court system's trying to work itself through that huge backlog of cases occasioned by COVID.
Yeah. Well, And I know the nut doesn't fall far from the tree in the Caulfield house either. So why don't you tell our listeners a little bit about your family, especially what happened last weekend?
Yeah, last weekend was a big weekend. My youngest, Sean, actually graduated from Stetson University College of Law, where I graduated from way back in 1988. And so I was certainly thrilled to be allowed to be included in the graduation ceremony, and wore the cap and gown, and ultimately was able to present my son with his diploma. So that was certainly one of the great thrills of my life.
That was really neat. You got to go up on stage and present him the diploma.
Yeah, actually, it was really fantastic to and it certainly brings back a lot of memories, when you're standing there in that courtyard where you were yourself some 35 years ago.
I remember that. I graduated from Stetson myself, and it was outdoors and it was very hot. So.
Yes, I remember that as well. And it was hot again that day.
Yes, welcome to Florida. But you started with the firm a long time ago when it was Pernick
and Carroll. Yeah, actually, I started at the firm in 1987. I started at the law firm when I was still a law student. So I was a law clerk first, then passed the bar, became a lawyer, and then, of course, became a partner about 3 years later in 1991, and I've been there ever since. So this is, I think September is going to mark my 35th year completed as an attorney.
Wow, that's wonderful. If you have any questions regarding personal injury or a trial process or really what happens once you get involved in a personal injury matter, whether it's a car accident, slip and fall, or other type of injury, give us a call now before the lines fill up. Again, the number is 727-441-3000. We are here to answer your questions. This is a live radio show, so we lawyers can keep talking and talking, but it's also better to be able to answer the questions that you all have. So please don't hesitate to give us a call at 441-3000. You can also watch us live on our Facebook channel. Our Facebook channel is Pernick, Caulfield, Averill, and Noyce Injury Lawyers. Brian and I are live on camera. We're waving to you now. So if you want to send us a message via Facebook, it's right here, right in front of me. I can be able to answer those questions as well. So please don't hesitate to jump on Facebook and send us a question via Facebook as well. So Brian, we were talking about your trial experience. You are, one of the hardest working trial lawyers I know, but you're also board certified. Can you tell our listeners what board certified means and what you have to do in order to become board certified?
Yeah, a board certification program is really kind of recognized as really the only objective way that you as a consumer can be assured of the experience and skill level of your attorney. You can't pay to be board certified. Board certification is a very rigorous process conducted by the Florida Bar, and only very few lawyers qualify to become board certified. You have to have had at least 15 jury trials. You have to go through a blind review process where your adversaries actually do a blind review of you, as does one of the judges you tried a case in front of. And only after you pass that process do you have an opportunity to then take the board certification exam. And of course, you have to pass that. Then you are board certified, but you don't remain board certified forever. It's in 5-year periods, and you have to continually demonstrate your skills in order to stay board certified. You have to try at least 2 cases to a jury during every 5-year period. And again, each time you're undergoing with your opponents reviewing you blindly. So you don't get to see what they say about you.
Right.
As well as a judge reviewing you blindly. And then you're re-awarded certification for another 5 years. So I've been certified since 1996, and I think I'm actually at 5 certifications, recertifications.
And there's not a lot of civil trial attorneys that are in fact board certified.
I am board certified in civil trial law. That is, there's less than 2% of all Florida lawyers are board certified as civil trial lawyers.
And we have 2 of them in our firm. We have you, and we have Lori Robinson, who was a guest on our show last week, and she will also be on next week as well.
Yeah, so. And Lori works very close with you and helps you try your cases. And, it's always, we always think it's a good idea, to have the services of a board certified civil trial lawyer available to our clients. And so, we place a lot of emphasis on that. And so, it's a program that more people are learning about. The Florida Bar is actually who does this program, and they promote the program. So it is a good way for consumers to find experienced lawyers that have demonstrated and proven their experience.
Right. And you and I tried a case together some time ago. It was a medical malpractice case, a very sad case, but that case required us to travel all over the country.
Yeah, I think I'm trying to remember it. I think we figured out we had like 11 different states is I think how many states we went through, because of course, when you have medical malpractice cases, they are very expert driven. So we have experts from all different parts of the country and different specialties. And when you have multiple defendants in the case, each defendant probably has 2 or 3 of their own experts. So the discovery process in those cases is quite long, quite rigorous, and quite expensive. So only certain cases you can ultimately really financially afford to bring. The medical malpractice laws here in Florida are so incredibly complicated. It just costs a lot of money to successfully bring these cases. So you can't bring a medical malpractice case for a small amount of damages, because the barriers built up to even be able to bring such a case just make that impossible financially to do.
No, that's right. In fact, I think in today's St. Pete Times, or Tampa Bay Times, I guess it's what it's called, showing my age there. I think there's a big long article about medical malpractice claims and how one of the patients that the article was about was she was misdiagnosed with having cancer, and so she suffered for many months thinking that she had cancer, and the article was like, well, thank goodness you don't have cancer. Sorry you had to go through everything you went through, but the medical malpractice statute says you really don't have a case.
Yeah, those are on those. It's certainly difficult to bring those types of cases. You've got to have a real kind of physical manifestation of harm, and those are cases that generally a lot of them don't get brought.
Right.
Normally the cases that you will see that actually get brought in the form of a lawsuit are ones where there is permanent physical injury and or death. Those are really the criteria that most lawyers won't even talk to you about a potential medical malpractice case unless the damages that you're complaining of fall into one of those 2 categories.
Right. And I have a lot of medical providers that are friends, I consider friends, and parents of classmates of my son. And I know they say, oh, you're a personal injury attorney, that blah, 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 blah. But really what I tell them is, listen, all we're trying to do is hold the bad actors accountable. You're a good actor. You're a good doctor. You don't have to worry about claims being made against you. And I think it's similar to we lawyers. There's some bad lawyers out there that do bad things to their clients, and they should be held accountable. And it just makes us as personal injury attorneys feel that we're doing the right thing, holding lawyers accountable to protect those clients, just like bringing bad actors in the medical field accountable to protect future patients.
Yeah, I mean, that's really what it's about, is accountability. When there's harm caused and the harm is as a result of a negligent act, if you're a driver on the road and you commit a negligent act and hurt or kill someone, you're going to be held responsible civilly for damages. And really, it's not any different ultimately for doctors. However, the doctors are a very powerful lobby here in the state of Florida, and there's a lot of intricacies, laws that are created that say you have to have an affidavit. You're going to have to go out and look and find a similar healthcare provider, and that doctor's going to have to review the records and be willing to swear out a written affidavit that reasonable grounds exist to believe that there was malpractice before you can ever get one of these cases off the ground. That's a very expensive process. And then there are different standards here. You can't even sue some types of doctors or healthcare providers for negligence. And by that, I mean, if your case is an emergency room setting,
right,
it's a heightened standard. You can only sue or complain of an injury from a healthcare provider if that healthcare provider is guilty of reckless disregard.
In the emergency room.
Yep, in the emergency room setting, or really while you're in an emergency state. Like, it doesn't just have to be in the emergency room. They take you up to the operating room and they're operating on you in an emergency situation. That same heightened standard is going to apply. And you can't bring a case against a physician or a nurse or other provider unless you prove that they were guilty not just of negligence, but the higher level of culpability known as reckless disregard. So, it's a very, very complicated statutory framework that has changed greatly over the period of time that I have been a lawyer over the last 35 years. So certainly, it's something that, we reject most of the cases that come in as telephone calls to us. We have to be very, careful in screening the cases, and we are.
Yeah, that's Brian Caulfield. He is a board-certified civil trial attorney, and I'm Matthew Noyce. We're both partners at Pernick Caulfield Averill and Noyce. Our main office is in Clearwater, but we've been serving Tampa Bay since 1955. We are the longest established personal injury law firm in Tampa Bay, and we're proud of that. And I think we earned that by showing our dedication to our clients and fighting the good fight when they need to be fought, and really guiding them through the whole litigation process. One of the unfairness that I've seen in the medical malpractice statute, since we're still talking med-mal a little bit, was the limitation on damages in a wrongful death case when it has to do with medical malpractice. Can you tell our listeners a little bit about that, Brian?
Yeah, sure. I mean, there was a number of years ago, there was a constitutional amendment that literally 2/3 of Florida voters voted that there should be a cap on non-economic damages. Non-economic damages are things like pain and suffering and mental anguish, and they're distinguished from economic damages, which are basically measurable math damages like medical bills and lost wages. So there was, in fact, a cap on non-economic damages placed. And fortunately, the Florida Supreme Court found that to be unconstitutional. Trying to force upon people a one-size-fits-all cap was found to be a violation of, your constitutional rights. And if you think about it, it's incredibly unfair that someone with a small case gets 100% of their damages, but people with extremely profound injuries, death, paralysis, blindness, that statutory cap operates to basically wipe away what a jury said the value of the case is and place an arbitrary one-size-fits-all limit. So I'm happy to report that the Florida Supreme Court found that to be unconstitutional. However, there's a big asterisk there because there is still a statute here in the law that allows a negligent healthcare provider to simply offer to admit that they were negligent and caused harm, either injury or death. And that entitles them to a $250,000 cap if we agree to accept their offer to admit liability and go arbitrate the case. You'd go to arbitration and you'd have a $250,000 cap on non-economic damages. Even worse and more unfair is if you refuse that offer to arbitrate, well, then the medical provider simply says, okay, well, then we're going to continue to fight you on negligence, even though we just offered to admit. We're going to fight you on negligence. You're not allowed to bring up the fact we made an offer to admit liability. And when you go to a trial, a jury's not told, but the jury doesn't know that they don't really have full power to render, a full verdict. They render a verdict, and if they find more than $350,000 in damages, the court automatically reduces it down to this, arbitrary cap of $350,000. So the point is there's still a problem with the law. And that so far is found to be constitutional with the argument that you give up something, but you get something in return. And what you supposedly get in return is the fact that your case can be decided quicker and cheaper without these defenses. So there's what they call in the law a quid pro quo that the court found to be acceptable. It's certainly not, but we're still dealing with that. And hopefully, at some point in the future, the court system will come around and recognize the incredible unfairness of that one-size-fits-all law.
Right. Well, that is very helpful. If you have questions regarding that, those caps or medical malpractice in general, Brian Caulfield's right here. He's here for the next half hour till 6 o'clock. We are here at FLA Law on the radio. Our number is 727-441-3000. But there's also one more statute that I think is totally an injustice, and especially in the medical malpractice arena, and that's when medical malpractice occurs, but there's no surviving spouse.
Yeah, that's something that there was a push in the legislature to try to change that, but unfortunately it fell short. And so,
what happens if there's clear medical malpractice, but there's no surviving spouse that results in the death of that person?
Yeah, unfortunately, there really isn't anyone to be able to bring a case. And so, anytime you look at a wrongful death act in Florida, what you're looking at is to see who the survivors are, because they're the ones that typically get to bring a case for wrongful death. And so it's just super unfortunate the way the law is written as it relates to medical malpractice, that, you have obviously a lot of folks here in the state who are elderly, since it's such a retirement haven. And unfortunately, when a medical malpractice act is committed upon them and they ultimately die as a result of the negligent mistake, people are shocked. I have every day almost, I have adult children coming in and say, hey, this physician committed clear malpractice upon my mom or my dad, and unfortunately they died as a result. And when I ask them the question, is there a surviving spouse, they kind of look at me with wonderment and say, well, who cares about that? There's 3 adult loving children here who should be able to make a claim. And I have to tell them, unfortunately, they don't qualify as survivors when it's a medical malpractice wrongful death, where if it was any other type of wrongful death and there wasn't a surviving spouse, the adult children could make a recovery.
I know, it's so unfair. I have 10 brothers and sisters, so there's 11 of us, and we're all over 30. And so if something would have happened to our parent because of medical malpractice, although we're very close to them, there'd be absolutely no claim that we could make.
Yeah, and there's really some other incredibly arbitrary things in the law where minor children are allowed to make a claim for the wrongful death of their parent. And minor children is defined as under age 25. So as crazy as it is to think about, you have a cause of action if your parent dies at 24 years and 11 months. But suddenly, if you're over 25 and they die the day after your 25th birthday, somehow you've lost your ability to make a claim. Just some really, really arbitrary things in our law that are really difficult to understand, and people are shocked when they actually hear about it.
No, I know. Well, it does look like we do have a caller. Caller, thank you for listening, and thank you for calling. How can we help you?
Hey, good afternoon. My name is, I'm getting feedback here. Hearing myself. Not a problem. I was very interested in what you were talking about earlier with the backlog of cases in Florida for personal injury actions and the resources used for ADR. I'm an attorney admitted in New York, and I moved down to beautiful Pinellas County. And
I don't blame you.
For more than one reason. It's not just the weather. What I found very interesting when I was going through mediation requirements, you may or may not know that you have to observe certain mediators.
Sure.
They're always lawyers. Was the difference in the liability issues and the injury issues as well. I know that some of these matters have been addressed by the legislature, such as surgeons charging 2-3 times more than the going rate for similar surgeries, which I was absolutely found outrageous. And the accidents where the impact, a rear-end collision less than 10 miles an hour where airbags don't deploy, allegations of herniated discs and such. I think that the legislature did a reasonably good job, but didn't really go quite far enough. what's your opinion on that as far as the damages issues?
Well, you mean far enough? Are you talking about the most recent legislative changes that have taken place that Governor DeSantis just signed into law, or are you talking about something related to alternative dispute resolution?
No, it's with regard to the legislation that was signed, I believe, on April 4.
Yeah, well, I mean, obviously you have looked at that, and there's been some sweeping changes in that as to what you're able to recover. And that law, if you think about it, that law is also going to be extremely unfair. That law basically changes many years of Florida law and allows now a defendant. So you gave an example about getting run into and rear-ended. Well, suppose you get run into and rear-ended and you end up with a serious injury and you go to a hospital and you end up getting admitted after a 5 or 6 day stay and maybe have surgery. Now, you're going to get rendered a bill from that hospital, from the surgeon, from a lot of doctors you never even met, radiologists, pathologists, etc. And what happens when you ask the at-fault party to pay that bill? Well, under the new law, the at-fault party is going to simply look at you and say, well, I don't like that hospital bill that was rendered to you. I think it's too high. And so we're only going to pay whatever it is, 120% of Medicare. And we'll offer you that so that you can pay off your medical bill in that regard. The only problem is the hospital is not required to accept from you that amount of money.
Yeah, the statute does not say that the hospital has to accept that amount.
So you could find yourself in a situation under the way the law is right now where let's say it's a negligent drunk driver that rear ends you and you end up with herniated cervical disc surgery. You can have that person say to you through their insurance company, we're not going to pay the full amount of your medical damages because there's this new law that says we should only have to pay up to 120% of Medicare. And sadly, that new law doesn't require the hospitals to take that. So there wasn't a great deal of thought put into that. And so that's a real life example of what could be happening here over the next year. I'm sure we're going to see more changes to that statute, but certainly, no one wants to be overbilled. Go ahead.
No, and thus that's why I say that this law did not go far enough. Both with the insurance companies and with plaintiffs' counsel and the doctor's bills, as you just pointed out, there's so many loopholes, just big glaring holes that I find that was not really addressed, and I'm kind of surprised that they weren't even a consideration of no-fault laws, where this an accident that results in severe damages, herniated discs, broken bones, et cetera, et cetera. In New York, we have summary judgment on such matters if a defendant didn't sustain severe injury. But yeah, people do sustain very severe injuries here. When I was first down here, I saw an accident on 19 that I was absolutely aghast. It was a downpour, summertime. Several cars involved in it, and the engine of one vehicle had been ejected from the engine compartment.
Wow.
Several feet down the road. Now, a car can run on one broken motor mount, really difficult for two, but for an impact to be at such a velocity that it would discharge an engine from the compartment, it shows you the rate of speed. I'm floored by things like that. So yes, obviously people were injured or worse in an accident such as that. I'm just surprised that the legislature didn't address this, because these are cases, I would say, Florida law with personal injury and auto accidents has to rival the amount that's in New York. I mean, it's voluminous. I used to battle with the partners of law firms that settling a case early and billable hours is not going to result in cases coming into the company drying up. It was
right.
Yeah, well, we have a very archaic no-fault law that was passed in 1973 that gives you, as a Florida citizen, if you're here now and you've been here for more than 90 of the preceding 365 days, then you're required to comply with Florida's motor vehicle no-fault law. And, what that's going to say is that if you're that person that's in that really terribly severe accident you described, that you have only $10,000 in medical coverage from your own auto insurance policy that pays 80% of your medical bills and 60% of your lost wages. And guess what? The person that, caused that incredible accident to you and caused you severe injuries, they have no requirement under their policy to have any money to pay for you. All they're required to have in Florida, because people come in and say, well, what do you mean, Mr. Caulfield? I heard that Florida is a mandatory insurance state. Well, yes, but that at-fault party only has to have $10,000 in property damage to pay for property damage to your vehicle, and don't have to have one red cent to pay for your injuries, your medical bills, your lost wages. And they're legal, and they have to have $10,000 to pay for their own injuries. So, if you look in the rearview mirror, that person behind you, if they have Florida's basic no-fault law, has no money to pay to you for your injuries, your medical bills, or lost wages, which is why Matt and I are probably in agreement that the most important coverage out there you should look for is uninsured motorist coverage, because there is a excellent chance that the person that's going to run into you is, number one, going to be completely uninsured, meaning having no bodily injury liability coverage to pay to you, or they could be grossly underinsured. Let's say they have a $10,000 policy, and you've ended up with surgeries that are in the hundreds of thousands. So the only way you can really protect yourself is to buy uninsured motorist coverage, and that's not mandatory. That's an optional coverage. So I would encourage you, coming from New York, the very first thing you ought to do is you better make sure that your agent has sold you uninsured motorist coverage here in Florida to protect you and your family members, whether they're in your car or whether they're in another car or whether they're riding a bike or whether they're a pedestrian.
Right. Is there mandatory bodily injury liability coverage in New York?
Yes.
Yes. That's what we think there should be.
We tried here in Florida. Actually, the last legislative session before this one
came close.
There was actually both, the House and the Senate voted in favor of putting a $25,000 mandatory liability requirement on every policy. Now, would that be perfect? No, but it's certainly a much better situation than having people driving around with no bodily injury liability coverage. And unfortunately and shockingly, the governor vetoed that. And so it's because, quite frankly, the insurance companies didn't want to be forced to sell a policy of insurance to every driver in Florida. They only want to pick and choose the ones that are likely to never cause a crash. The problem is the insurance framework we have here in Florida leaves you at great risk, especially if you don't have health insurance.
And that's why if someone says that they have full coverage, that doesn't mean anything to us.
Nope.
Because full coverage in Florida just means you have PIP and property damage. Thank you for listening, and thank you for the questions. Very helpful, and I hope we were able to address some of the questions that you have.
Oh, yeah, definitely. I think that getting that information out there to the public, this discussion that we just had, is absolutely germane to people being aware of what they're being exposed to, and when they go to the voting booth, to understand that these issues are very, very important. Like I said, there's a tremendous amount of differences between the issues in New York litigation versus Florida litigation in these automobile accidents. And as I was discovering the nuances, I was kind of shocked.
Yeah.
And then to find out that April 4, they changed the law. And I was really hopeful that it was going to reflect a little bit more of what I'm used to in New York. Not that New York is the end-all and be-all, it's not.
No.
But to get a little bit closer to that. And no, they missed it. And that's what I was trying to prompt a discussion about.
No, I think that's very good discussion. Thank you for calling. We are going to take our break for right now, just a minute break. It did free up a line. Again, while we're on break, give us a call at 727-441-3000. We'll be right back on FLA Law on the radio.
This This is the Tan Talk Radio Network.
In 1955, the law firm now known as Pernick, Caulfield, Averill, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, call Pernick, Caulfield, Averill, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
This is the Tan Talk Radio Network.
Welcome back to FLA Law on the radio. My name is Matthew Noyes. I'm one of the attorneys at Pernick, Caulfield, Averill, and Noyes. And I have Caulfield there too, Brian Caulfield, my law partner here. We're here to answer questions that you have. Our number is 441-3000. It does look like we do have a caller on the line. Caitlin, thank you for calling. How can we help you?
Hi. So last week I came home and I got my mail, and lo and behold, I got a jury summons.
Oh.
There's a lot of information on it, but obviously I work, and so what can I expect for this? Do I just go? Am I there all day? What happens with that?
You called on the perfect day.
Been there, done that today.
Brian Caulfield, what did you do this morning?
Yeah, actually today, I actually went to serve as a juror down at the criminal court complex on 49th Street. So good question as to what you can expect. As a resident of the state of Florida, if you've got a driver's license, you can expect that one day you're going to get summoned for jury duty. And that is, as the judge said today, that is your civic duty. And according to the judge, who did a very fine job, I thought, the judge actually talked about how behind military service, it's really the second greatest thing we can do for our country.
Yeah, it's not just a duty, it's a privilege, I would think.
It really is. And, unfortunately, frankly, jurors are really not treated good enough. And, they should be celebrated more. They should be paid more. But the system that we presently have in place, I was summoned to be there at 8:30 this morning, which I was. And then what you can expect ultimately is a large number of people will assemble into a central jury room. And while people are kind of signing in and doing that, all the while up on the floors above you at the criminal court complex in Clearwater, people are busy at work trying to determine which cases are going to resolve and which cases are going to actually need jurors to resolve the disputes between the state of Florida and a criminal defendant. And so ultimately around 10:30 or so, the word started coming down from the different judges who were going to need jurors to come to their courtroom to undergo the jury selection process. So along around 10:30 or 11, we all started getting summoned, and the bailiffs would essentially get a list from the clerk, and they would bring up 25 to 30 jurors to each courtroom. And then you undergo the voir dire process, which is where first the judge and then later the lawyers for each party will ask you questions. And those questions are designed to just try to understand who you are and your level of fitness for service. And by that, I mean, essentially, they're trying to find jurors who can render a fair and impartial verdict. So they'll put you through questioning to determine, is there any reason, things that have happened in your past, how you feel about, certain types of witnesses that will be in that case.
Now, do both sides get to ask you those questions?
Both sides do. The prosecution would go first in a criminal case, and then the defendant's lawyers get to ask you questions. And if you happen to be summoned on the civil side, then you're going to end up at a courthouse in downtown Clearwater, or you're going to end up at one If it's Pinellas County, you're going to be south of Ulmerton Road. You're going to end up down at the one in downtown. And if you're over on the other side of the bay, over in Hillsborough, you're going to end up in downtown Tampa. And those questions will be similar, except it's a civil case. So the person bringing the case is called the plaintiff. Their lawyers will ask questions after the judge asks some preliminary questions. And then after they're done, then the defendant in the civil suit has an opportunity to question jurors. And what they're really trying to do is do two things. They're trying to, number one, determine if there are any persons on there that simply because of their background or for whatever other reason, they just can't be fair to one of the litigants. If you like to think of it, one person starts further ahead than the other. And so the law recognizes that all people have kind of biases and prejudices that, are just a product of living. If you have a family where both your parents are police officers, then you're probably going to say that I automatically believe the police officer over anybody. And if you were to say things like that, that could ultimately get what's called a challenge for cause, where the judge would make a decision that, hey, really, you ought to be sitting and listening to another, type of trial.
And it doesn't mean that they're wrong to have that position. They're perfectly all right to have that position that they believe in the police officers, or in our civil cases, they believe in chiropractic care. They just may not be right for that particular case.
It's a free country. People are allowed to have their views, and that could make them, a fantastic juror for maybe a case down the hall that's having a real estate type fight or issue. But the point is, they don't have any preconceived notions or feelings toward one of the litigants or toward some of the main witnesses in the case that might cause them to favor or disfavor them. So you're really trying to build any challenge for cause, it's called. But then you also, as a litigant, you have what are known as preemptory challenges, where you can actually strike, up to 3 people that, for whatever reason, you just, after listening to them, maybe it's just a feeling you get that they don't like your side of the case. And so, that's kind of an art in addition to the science of jury selection. So jury selection, if you ask me, absolutely critical part of the case. And sadly, what's happening as a result of COVID and the effort to really race these cases through the docket, we're now having these incredibly arbitrary limits, like 45 minutes or 30 minutes each side to do voir dire, which is certainly an impossibility. When you bring 30 strangers in, you have literally less than 1 minute per person to try to ask questions, to try to get an understanding of their mindset and their life experience. So really some unfortunate changes in the law, but I continue to think that the jury selection process is the most important part of your trial.
And I don't think I don't know if you're allowed to answer this or not, but were you picked for a jury today?
I was not selected. I, of course, was, summoned from the central jury room to go to a courtroom. And, there was a criminal defendant there, and the judge asked some questions. And then ultimately, each side, first the state of Florida's state attorneys, ask questions of the jury panel, and then the lawyer for the individual defendant ask questions. And then when they are done, they ask all the jurors to step outside for a minute. They make arguments about who should serve and who might be better to serve on a different case. And then ultimately, they bring you back into the courtroom, and then they announce whether you have been selected. And I was not selected. So one side or the other, I don't know which one, they don't have to tell me, but for some reason, one of the parties decided that they didn't think that I would be, a fair and impartial or favorable juror for them. And they kind of got to use the art of jury selection. And perhaps it was because I'm an attorney. They might think, hey, he's going to be strictly applying the law, and that might not be good for my particular client. So you really don't know. But ultimately, I served, and then I, have made it onto a jury before. So this was actually my 3rd time being summoned.
Wow. I've only been asked to show up twice and only was questioned once so far. Kayla, was that helpful for you?
Absolutely.
Good. And I'm very glad to hear you didn't say, how do I get out of serving jury duty? Because I always scold people who ask me how to get out of jury duty, because I think it is a privilege to serve on a jury. And so have fun, enjoy the experience. And thank you for listening, and thank you for calling.
Thanks for the info.
Sure.
Take care.
Sure. One of the questions that they would ask in one of our types of cases, a car accident case, is can you serve as a juror long enough to hear this case? Can you tell our listeners about how long does a standard automobile accident trial last?
Yeah, I mean, standard civil cases for auto accidents are usually a minimum of 3 days.
At least, yeah.
At least 3 days. And these days, it's even more and more difficult to do them in 3 days. So, ultimately, when you're forced to bring in all of your healthcare providers to prove that you sustained a permanent injury as a result of the accident, that requires a lot of medical proof. So what people really don't understand is most of the trials that we go to trial on, we're not down there fighting about who caused the accident. Many of these cases are rear end collisions where people have, slammed into our clients from the rear, and there's no doubt they admit they were negligent, but the way they try to defend the case is say that you have not reached Florida's no fault threshold.
Right.
You have not proven that you have a permanent injury as a result of the accident.
Why does that matter, though?
Matters big time in Florida because of our no fault law. So if you don't prove that you have a permanent injury within a reasonable degree of medical probability as a result of the accident, you are not entitled to non-economic damages. So
those are the pain and suffering,
mental anguish. I like to call them they're not the math damages. The math, something that's easily done by mathematics, is what are known as economic damages, medical bills and lost wages. So
I call them PETA damages, painted what damages.
Okay. Yeah, so it's really a big difference. And if a jury were to find that even though you were rear-ended and the other driver was negligent, if they find you didn't sustain a permanent injury as a result of the accident, they are not permitted to award you any money for non-economic damages. So this is what we fight about. Two-part issue. Is the injury permanent? And number two, is it causally related to the accident? So the insurance company is going to reach backwards in time to see if you've had any other type of injury or medical care that they could say is actually the cause of your current neck or back pain, for example. And then they'll even look subsequent to the accident. Maybe you've had another accident since you were run into, and maybe the new accident's your fault. And so then they'll try to say, well, that must be the accident that injured you. Plus, even better, when they don't have any doctor to say that you didn't sustain a permanent injury, they have the ability to go out and get one. And by that, I mean they have what's known as power of compulsory medical examinations, where they can compel you to go to a doctor of their selection.
One of their hired guns,
and then that doctor can come in as a witness against you.
Right.
And many times it's the same doctors over and over and over again.
Who get paid a lot of money from the insurance companies to come testify.
Quite an industry.
Yeah. Now, we keep saying insurance companies, but can juries really understand that it's the insurance company on the other side?
No, in the good old days of Florida, there used to be, when you would sue someone, you would sue them and their insurance company. But the insurance company is very powerful here in the state, and they basically lobbied the legislature, and they felt that people were giving money too easily to plaintiffs because they knew that there was insurance in the case. So they passed something known as a non-joinder statute. And it basically says you can no longer join the at-fault party's insurance company. And so now essentially, basically the style of the case is the person who is injured versus the driver and owner and or employer of the person driving the offending vehicle. And then almost always we're getting a case during jury selection. Hey, did this person have insurance? And that's like totally taboo now. You're not allowed to, you have to even be careful of, do you respond to that question at all? What I do is I turn to the judge and let the judge respond. And the judge will say things like, whether or not the person has insurance is irrelevant to your decision. But, it always worries you because, when I do question people, why they're asking, like, well, if I find this person doesn't have any insurance, then I don't want to give an award against them. I've had people say things like that. So,
Right.
You really, unfortunately, can be hurt the other way, where if jurors assume that the person doesn't have coverage, they're not as likely to give damage.
Well, I had a case like that. We ended up in a mistrial or a hung jury because although the at-fault driver had insurance, one of the jurors felt sorry for him. He had dreadlocks and he put his head on the table throughout the whole trial. He just looked very pathetic. And that juror felt very sorry for him and came running out of the jury room saying, I can't have him pay anything to that person. And it was like, well, if we could only have known that there was insurance involved, then it wouldn't have
Yeah,
happened.
I mean, unfortunately, if you're going to take the position that the presence of insurance causes people to award more money, then the corollary of that is, well, maybe the fact that they think there's no insurance will cause them to unfairly give a person less than they deserve. But it's an unfortunate fact, but the way the law has decided to deal with it is not to let the jurors know the true state of affairs. That is that there is liability insurance and that it's the liability insurance carrier that's pulling the puppet strings. They're the ones that make a decision whether to settle the case, regardless if the at-fault driver would like to settle the case and be done.
Right, exactly.
Their own insurance company gets to say, sit down and shut up. We're taking care of this. We're making the decisions. And believe it or not, you give them the power to do that in your insurance contract.
Right. Now, Brian, you and I have been trial attorneys for decades, but you've got to do something that I have yet been able to do, and that you appeared in front of the U.S. Supreme Court.
Yeah, the U.S. Supreme Court actually didn't just only argued through briefs.
Yeah.
But certainly I did have a very interesting case that's still ongoing where someone unfortunately had taken some medications that weren't prescribed. And so issues came up with regard to me wanting to get their blood, to test their blood. And believe it or not, those issues generated appeals all the way to the United States Supreme Court.
Almost all of our cases never get to the U.S. Supreme Court.
Never, yep. It certainly was probably 1 in a million.
Yeah. So, well, that is Brian Caulfield. He is a board certified civil trial attorney. He's been a partner at Parent Caulfield, Averill, and Noyce for decades. I am Matthew Noyce. I'm also an attorney at Parent Caulfield, Averill, and Noyce. And we proudly represent people who get hurt, have to fight insurance companies. If you have questions off the air about a car accident, workers' compensation claim, Social Security disability, medical malpractice, Brian, what's the best way that they can reach us?
Well, the best way to reach us is simply by calling our law office at 727-796-8282. Another way to reach us, of course, is through the web. You can go on the web. The website address is usalaw.com. There you'll have the ability to contact us through email. And certainly we're happy to respond to all your texts. And the take-home message we'd like you all to have is to check your auto insurance policy and make sure that you have coverage known as uninsured motorist coverage. If you've been advised by your insurance agent to reject that, that's the worst possible advice you could ever get. So please check that out. Please be safe. But if you do have need for injury attorneys, we've been here since 1955.
Yes, and thank you for listening to this hour. We encourage you to listen to us next week on Tuesday at 5 o'clock. I think it's Jacqueline and Lori will be there. But in the meantime, this is Matthew Noyce signing out. Drive safely and watch out for those who don't. Good night.